Hello. Today we're going to talk about Burlington versus White, which is a case that was decided by the Supreme Court in 2006, and it follows in the line of Meritor versus Vincennes from 1986, and then the Lisa Harris versus Forklift case that was decided a couple years later. So this case is happening after those, but it follows in the same stream because the Supreme Court is trying to evaluate what, if anything, a employer has to do when an employee alleges that they have been subjected to a sexually harassing environment. So let's start by looking at some of the key facts and figuring out who's involved in this case. So first up, we have Sheila White, who was unemployed for a year when she got a position at Burlington Northern. So if you click on her name, that will take you to just a picture of her and some brief information about her. But in addition to kind of what we talked about in the textbook, she was applying to be a track laborer. Now, this is going to become really important later because track laborers did the very physical work of making sure that the railroad lines for Burlington Northern were operational, that they were free of debris, that they were free of anything that would cause the train to derail. If there was anything that needed to be repaired, the track laborers were the ones providing that physical labor. So hang on to this, because what happens is that she's going to be hired to be a track laborer, which is the very entry-level physical type of job for the railroad. And then when she reports for duty on July 2nd, 1997, she's going to actually operate as a forklift operator. So what this means is that she's hired to do physical labor, but instead she's driving the heavy equipment and operating it because she'd done that on a prior job. So even though there are 100 people in this department and she's the only woman operating in it, she's one of two people basically who are able to operate the forklifts. So she, in a sense, almost gets immediately promoted while still being a track laborer. This is going to become really important. Now, Burlington Northern is a major railroad company. Marvin Brown is the gentleman who hires her, but Bill Joyner is his immediate supervisor. And almost immediately, from the moment she starts working, he makes it very clear that he believes women should not be working in the department and should not be taking a job that could go for a man. So she complains to Burlington Northern. She's savvy enough to know that she has some rights to be free from a sexually harassing environment. And the statements he's making are very much related to women, so to her and this job. Burlington suspends Joyner for 10 days and orders him to attend sexual harassment training. And one of the questions that I like to talk about is whether or not that's a sufficient response. So one of the challenges for companies is that when an employee complains that they've had a sexually harassing experience, and remember, the Supreme Court in Harris said, we're going to use the subjective standard. We're going to try and make a very subjective analysis of whether or not it's a hostile work environment. We're going to try and make it more objective by saying we're going to look at the reasonable person. What would a reasonable person who is planted inside your environment and situation, what would they think? Is that a harassing environment or not? So a company now, because of, in part, what Meritor set up with this, as long as there's a reporting line, then before an employee can sue, they have to go through that internal process. So Burlington Northern has this internal process. They're trying to objectify a very subjective experience. And so they put him on 10 days of suspension and make him go to sexual harassment training. Now, a challenge for employers is, what if I'm the person who complained and I'm not satisfied with that? I might still sue, even though the company has done everything that the Supreme Court has said that they need to do. And so Burlington Northern's kind of stuck in that quagmire right now. And so we could talk about whether or not this is a sufficient response to White's complaint. Then on September 26th, White, is told about Joyner's discipline. And then Brown removes her from forklift duty. So she's assigned to only the traditional track laborer task, and a more senior man should have the less arduous, the less physical job of forklift operator. So again, this is where I want you to stop and think about, is there a problem? Is there a challenge here? Is there anything in these sets of circumstances that would equate to a tangible employment action? And if we were in class, we would kind of talk through this. So I want you to think about that, and it should probably be evaluated in your brief if you're talking about that. All right, so then on October 10th, 1997, White files a complaint with the EEOC, and she claims that her reassignment is basically retaliation for her earlier complaint against Joyner. That, in a sense, she filed her complaint with her employer like she was supposed to, and then as a result of that, she was demoted from forklift operator to a track laborer. Then in December, she files a second complaint because she's under constant surveillance and her supervisor is monitoring her daily activities. So in a sense, she's like, I can't do my job because I'm constantly being watched and evaluated, and nobody else in this department is. I'm the only one. Therefore, this feels, again, like retaliation because I filed the complaint with the EEOC. So she's a very savvy woman who is protecting her rights under Title VII and really documenting everything that the company is doing. Now, remember, if you file a complaint, you have 180 days from that event. And each time there's a new discriminatory action, that's a new event that requires a new complaint. So she's following that protocol very effectively. Then she's suspended without pay. She follows the internal union grievance process because this is a unionized workforce. And the result of that internal grievance process is that she's not insubordinate. She gets her job back, plus back pay for the 37 days she was suspended. She then files an additional retaliation charge with the EEOC because she was suspended. So she now has 3 pending actions with the EEOC. So I've dropped a couple of links here for you related to retaliation, both at the EEOC website, which are very easy to read and understand. So it'll just give you a little more background on what constitutes retaliation. But the way to think about it is that if you've exercised any of your rights under, in this case, Title VII, and then your employer takes action against you that results in some type of tangible employment action that's adverse, then that can be retaliation for exercising your legal right to file, in this case, a charge with the EEOC. So that's what she's alleging. Okay, so now she's going to go, she gets her right to sue letter, or letters in this case, and she's going to file. So with the procedural history at the district court, she's claiming that her changing job responsibilities and suspending her from her job both equaled retaliation for complaining about the sexually harassing environment. She had a jury in this case, which is interesting. Most of the cases we've looked at so far have been in front of a judge and did not involve a jury. And the jury finds in her favor and awards her roughly $47,000 in expenses. The judge refuses to overturn the jury decision when asked to do that by Burlington Northern, and says that the harsh realities of track labor made it, for all intents and purposes, a demotion, despite it paying the same wages for forklift work. So where this becomes important is she's not suffering a change in pay, it's a change in working condition. And the district court is saying that's still a tangibly adverse. It'd be like going from secretarial to maintenance. And so the court's like, that's not going to be okay in this situation. The Court of Appeals is initially divided, and then the full Court of Appeals, in an en banc opinion, vacates the 3-panel decision, and so they agree with the district court. And what happens is we've got this environment that the Supreme Court's now looking at a split among the circuits. So the Sixth Circuit says most show adverse employment action, materially adverse. The Fifth and Eighth are more restrictive. It's an ultimate employment decision. So things such as granting leave, discharge, things like that. And then you also have the 7th and DC Circuit that say that the plaintiff or the employee must show that the employer's challenged action would have been material to a reasonable employee, so pulling in some of that reasonable language. And then the 9th Circuit and the EEOC say that it's simply establishing adverse treatment that is based on a retaliatory motive. So it's the easiest to prove. And so that's what the Supreme Court's being confronted with after this case, is you've got this incredible split among the circuits, and because of that, it's right for the Supreme Court to take and make a decision. So the issue that the Supreme Court is evaluating is, does Title VII's anti-retaliation provision forbid only those employer actions and resulting harms that are related to employment in the workplace, and how harmful must that action be? So the 1991 Civil Rights Act expanded Title VII to allow recovery for emotional distress damages, something we saw in the Harris versus Forklift case. So now it's not just limited to back pay, any pay you should have received but did not. It's now been expanded to include things like punitive damages. So two of the cases that were referenced by the Supreme Court were Farragher and Ellerth, which came out in 1998. In these cases, we're exploring whether or not an employer is responsible for the actions of an employee against another employee. So that top line there is basically quid pro quo. If the harasser uses his authority to take some sort of tangible action, then the company is automatically liable. So we have talked about that multiple times because that's the quid pro quo standard. So quid pro quo, if it's a manager, a supervisor who has authority to make that threat or make that claim because the employer put them in that position, then the employer's always liable. There are no exceptions or questions about that. If the harasser merely creates an abusive environment, then the employer can defeat it by showing that they implemented preventative measures and the employee didn't use them. So this comes back to the meritorious standard of, if there's an alternate route to report the harassment and the employee doesn't access that, they can't sue. They have to go through the internal process first. This is also why most companies have anti-harassment workplace policies. They'll do some type of anti-harassment training. All of these are those preventative measures that the Supreme Court was looking for in Farragher and Ellerth. All right. So Farragher is a case from 1998 in Baton Rouge where Beth Ann Farragher was a lifeguard, and she resigns because she alleges her supervisors had created a sexually hostile environment with touching comments, things like that. And so she says that's discrimination, and the district court concluded that the conduct was sufficiently serious to alter the conditions of her employment and constitute an abusive working environment. Then the full panel of the Court of Appeals held that Farragher's supervisors were not acting within the scope of their employment. Basically, the Court of Appeals is saying no employer would tell a supervisor that they need to harass their employees. But the Supreme Court said in a 7-2 opinion that the employer is vicariously liable for those actions caused by a supervisor, and that the liability is subject to an affirmative defense about the reasonableness of the employer's conduct, as well as that of the plaintiff. So that's what the court's evaluating and deciding with Farragher. The same day, they handed down the opinion in Ellerth, which was opposite Burlington Industries, and she quit because she said she suffered sexual harassment from her supervisor, but she didn't suffer any tangible retaliation, but was instead promoted. So this kind of sounds like Meritor, where Vinson was promoted and gets all these advancements while she's being harassed. And she was silent, even though she knew about the sexual harassment policy, but she claimed that she was constructively discharged. So the issue the Supreme Court was asking or answering in this case was, can an employee who, despite refusing sexually harassing advances and suffers no adverse job-related consequences, can that employee recover against an employer under Title VII without showing that the employer was responsible for the supervisor's harassing conduct? And what the court said is yes. Again, 7-2. The exact same judges who were 7-2 in the other case are again the same here. And they're saying that supervisors can create hostile working conditions and the employer can be liable. Again, it's the supervisor who's doing it. So the employer, though, does have the defense of showing that they responded quickly to prevent harassment. And so that's the environment that this case against Burlington Northern is happening in. So what's the key argument by White's attorney at the Supreme Court? Basically, they're saying you have to provide for constructive discharge because if you require employees to complain, which White did, she complained to her employer, and then she was potentially retaliated against. You're creating an environment where you tell employees they have to complain, but when they complain, they're going to be harmed. And in that situation, they're not going to complain because the result is going to be a demotion or suspension, the kinds of things that White experienced. And so her attorney's arguing that you have to provide for constructive discharge for anti-retaliation, or it's a pseudo right because employees can't actually exercise it. So the court ends up adopting the EEOC standard, which you'll remember that was linked with the Ninth Circuit, that the employee only needs to show that the employer took adverse action that would have dissuaded, again, a reasonable worker from making or supporting a charge of discrimination. So the other thing is, this includes people who are going to testify on behalf of the person who's alleging discrimination, or a supervisor who's helping their employee through that process. So they're going to have protections as well. All right, so that's Burlington versus White. As always, if you have questions, post them on the discussion board or email them to me. But that gives you the context of the case and how it's contributing to the Title VII environment in the United States related to sex.